Thank you for attending this evening. This is the first of 5 planned events in a JLL Junior Labour Lawyer Impact Brexit series. And this is the JLL Impact of Brexit and People discussion, focusing on workers' rights and movement and political protections. The other events will continue next week. We have an event on trade, relationships and business, post-Brexit and Labour's position on those issues, followed later in the spring with some events on devolution, Brexit as a constitutional moment, and individuals' rights post-Brexit, some of which we are, of course, going to be touching on today. So in this first event, we're going to, as I say, discuss some of the political protections that we can see may be endangered by Brexit. And I'm really happy that we've got Julie Ward, former Labour MEP for the North West, who sat from 2014 to 2020 in to discuss her work with the European Parliament as an MEP and some of the things that she's not able to do at that level, but hopefully she can discuss how else we can provide those that political support for vulnerable communities. We'll then hear from Grahame Anderson, who is an employment barrister at Littleton Chambers, who's going to look at some of the employment law protections, workers' rights that perhaps we enjoy and perhaps are endangered, and how Brexit essentially will impact those positions and statuses. We'll then come to 2 short pieces on immigration. First, Bella Mosselmans, who is an immigration and asylum lawyer at Safe Passage, working with the arrival of unaccompanied minors to the UK. Bella's also co-founder of Here for Good, which is a legal advice charity that assists European nationals and their family members with EU settlement scheme applications. So Bella will talk to us about some of the impacts of individuals, overseas national individuals in the UK as a result of Brexit. And I understand there are some quite significant ones that have already started to take hold. And then I'll just round off with a very quick look at some of the ways in which people coming to the UK to work, so overseas nationals coming to the UK to work, have been impacted by Brexit, both non-EEA nationals for whom the points-based system that existed before has essentially remained consistent, and for those from the EU coming to work in the UK, how we have a very different position now. So I'm gonna let Julie get going and pass over to her. Yeah, thank you. Oh, sorry. Just before I do that, I should mention, so if each speaker could stick to 10 to 15 minutes or so, I'll look at questions coming in, which I ask attendees to put in the Q&A box. And if we're getting quite a few, I'll hurry up the speakers. If not, I'll let you speak at length. And if you have comments rather than questions, if you can put them in the chat box so that it's easier for the panel to look at questions when we come to those at the end. Thank you. Sorry. Thanks, Julie. Over to you.
Okay, thank you very much. Ahmad, it's really nice to see you, meet you properly, because you were fantastic at helping me with something, and I just want to sort of pay credit really to our amazing community of Labour lawyers. So my name is Julie Ward, and as Ahmad introduced me, I was a MEP for 5.5 years. And in fact, we met because I'm subsequently a member of the Britain in Europe think tank at Goldsmiths Law Department, which I was quite surprised to be invited to, because I never studied law at all, even though I became a co-legislator. So I thought I'd just talk a little bit about my background really and my motivation for going into politics, and because I think it's important to understand why I did what I did. So I always felt I was an accidental politician. I was working in the arts. I'm actually a poet and a theatre maker. primarily, and I'd never even been a councillor, or never run for MP or anything. I mean, the only kind of election I'd ever participated on was to be a school governor, because I was the only parent who ever bothered to turn up to the to the school parent meetings. But I, as a result of working in culture, I had participated in a lot of cultural exchange projects, both myself as a cultural practitioner and a cultural manager, which were European funded projects. And in fact, I'd been running a cooperative which had received, so I'm based in the north of England. I'm in a marginalised, very deprived community, and I had established a cooperative that was working with all those deprived communities, working with lots of people who are unemployed or underemployed, lots of people with mental health problems, lots of NEETs, lots of young people who were not in education, employment or training. And many of the programs that we were running had funding from European Regional Development Funds, so ERDF funds and ESF funds. And I was also participating with lots of young people that I worked with. I was participating with them, taking them on a regular basis to meet with their peers from other European countries to talk about common issues, things that concern them all, and to do that through arts and culture. And so my vision of the EU was a very different vision from the vision that was being portrayed in the Daily Mail and the Express, and increasingly in the Telegraph. I always saw the EU as a peace project. I still see it as a peace project, and that it fundamentally needs to belong to people, not to institutions. I didn't even quite understand when people were talking about a democratic deficit. I didn't even quite understand that, because for me, if you had those people-to-people contacts, if you were engaging, if you were outward looking, if you were interested and curious and wanted to collaborate with people, the EU was the perfect mechanism to do that. And so I began to lose sleep because of the right-wing narrative about the EU and all the lies that were in it. And I really felt that I needed to defend it. So that led me to apply to be an MEP, which meant, in fact, filling out a form and submitting my form in December 2012. It was a very long process at that time. So that was 18 months even before the elections took place. And I have been very consistent all the way through my campaign to be on the list. Then in my working with the team to campaign to win the election throughout my whole mandate, and to really fight for that continued kind of people-to-people relationship, which is what I think is really important. So the Labour Party put me, so if I say EPLP to you, that's the European Parliamentary Labour Party, okay? So it's like the PLP, but it's got an E in front of it. So we were a very small group. We were 20 when I was elected in 2014. We were only 10 when I was re-elected in 2019. But there are 20 standing committees in the European Parliament, and each MEP, each EPLP member was allocated one main committee to represent the Labour Party, in a European context on that committee, and to work hard doing that job and take it seriously. So my responsibility was to be the main person on the Education and Culture Committee. So from the perspective of being a lawmaker on that committee, so education is a member state competence. So we weren't making a lot of law to do with education. We were mostly doing best practice, sharing best practice, policy recommendations. The most important piece of work that I did was a report on Intercultural Dialogue, Diversity and Education for Fundamental Values, which was the committee's response to the Charlie Hebdo murders and the Danish attacks. And it was a very important report because it was off the back of the Paris agreement, which was when all 28 education ministers went to Paris to talk about how to tackle the root causes of extremism rather than always tackling the end result, which is, violence, attacks, all kinds of hate crimes and extreme violent events and murder. So my take on it is actually every time there's yet another incident, what happens is that governments make a knee-jerk response by more surveillance, more borders, more limitations on civil rights, more laws, more armed police, whatever. And that doesn't really attack the root cause of the problem, which is to ask, why do people become extreme? Why do they listen to those extremist views and then in the end put their own lives at risk, frankly, and become estranged from their families, from their communities? So that was my main piece of work, but I am really proud that I was one of the most hardworking, busiest, active MEPs in the Parliament during both of my mandates. And that's because when you're elected as an MEP, you can be as busy as you want. And it means that you can be very active on lots of other committees as well, and lots of other kind of extra parliamentary work. So I also had 2 other committees that I was what's called a substitute for. So this means that if a main committee member from my political group couldn't turn up for a vote, it was my job to go and make sure that we voted. Okay, so I would be, but also being a substitute, you were given responsibility to write reports, to write opinions, to submit amendments and all the rest of it. So we could still be really, really busy on those other committees. And my other committees were women's rights and gender equality, which doesn't make any law at all. I have to say to you, that committee doesn't make any law at all, but it has gender mainstreaming. MEPs who are responsible for gender mainstreaming focal points on each of the other committees. So we were trying to take a kind of horizontal view to ensure that all the work that the Parliament was doing was taking account of gender. And I was also on the Regional Development Committee, and regional development was all about the money and the programmes and everything that comes back to the regions. And also, I should say, the solidarity funding, which is for communities that and countries that experience natural events of great disaster. So, for example, I fought for the UK to get the solidarity money when we had the terrible floods of December 2014, or was it 2015? Yeah, I think it was 2015. I was involved in making some law. So in the Culture and Education Committee, we were doing a lot of copyright law and a lot of law around audiovisual media services directives. So I did work on those laws, and I was also responsible for the revamping of the Marrakesh Treaty, which was the law that it's the legal act that makes broadcast works accessible to people with impaired vision, so blind people, for example. I was also the Culture and Education Committee's link MEP with with the United Nations Committee on the Rights for Disabled People. So you can see the link there between my work on the Marrakesh Treaty and my work as a link MEP, and I was really pleased to be given that role because I ran a disability organisation about 20 years ago, and I have been a disability campaigner all my life, disability rights campaigner all my life. So maybe that leads me to talk about human rights then. So I'm also a child rights campaigner, and one of the first things that I did when I entered the Parliament was to co-found a children's rights intergroup. And intergroups are like APPGs, so the all-party political groups on a variety of different subjects, you know, that are outside of the main committees. So I co-founded a child rights group. I was a co-chair of that, I think, or co-president. I also was a member of the intergroups on disability, on LGBT, on youth, on trade unions, on anti-poverty, on cultural and creative industries, and on common goods and public services as well. So could be super busy with all those things. It was at 24. It was a busy life. Sorry, there was something that I was thinking I needed to say to you about. Sorry, yes, another really important piece of legislation that I was working on when we did Brexit was that I was with Sir Julian King, the British Commissioner, and with a Conservative MEP, we were the team writing the new legislation about extremism content online. And that we never finished that process because of Brexit, but I often think about how crazy it is that this country was so kind of consumed with xenophobia and worries about, you know, people of colour coming here to terrorise us, that we would do Brexit. And 3 British lawmakers were making a new law, a good law, about how to keep people safe online and how to prevent extremist content by making the tech companies responsible. And this was largely the result of it was kind of kicked into action very much because of the attack on the mosque in New Zealand, but it had been in discussion for some time. So you can see there, you know, like what a loss it is not to have the British voice in those negotiations and in that actual sort of technical work. Yes, I was going to talk to you about human rights because I think that's important. So I was child rights campaigner, disability rights, all the rest of it. But what I discovered, what happened very quickly, is that all rights ended up at my doorstep. And that is because not enough MEPs are working on human rights. And so a whole range of human rights issues, from people on death row, you know, to people being tortured, to people not being allowed visits in prisons, to people, you know, extrajudicial kind of, you know, processes. So a whole range of different human rights abuses and globally were issues that I ended up working on. And that isn't about making law, but it is about putting something at the heart of what you believe in, which is, for me, human rights became the foundation of all my work. I felt that if we couldn't respect human rights as lawmakers, then everything else really might as well go to hell, because, you know, what is a trade agreement without human rights clauses in it? Yeah, that for me is really, really important. And now we're seeing, you know, out of the EU, the amendment about the genocide amendment was voted down yesterday. We're seeing all kinds of really, really worrying things that the Conservatives now feel they can play fast and loose with. And maybe just to return to people, because that's how you started talking, and about employment and all the rest of it. I was responsible, well, our political group won a fantastic success, really achievement, in the Work-Life Balance Directive, which is one of the last things that we passed, which gives carers paid leave. And, you know, for all the talk in this country about looking after carers, a law that we made and passed gave both maternity and equal maternity and paternity leave. So it improved the maternity directive and gave paid leave to carers. And of course, we're not going to be implementing that law here in the UK. And I think that it's those kinds of things where inch by inch, step by step, you know, committee by committee, report by report, amendment by amendment, liaising and talking with social partners. We never made a single report or wrote a single amendment or did any work at all without having exchanges of views with social partners who were largely trade unions, but also organisations like human rights organisations, the anti-poverty network that I worked really, really closely with. And I do not see that happening in Westminster. So, you know, also, and people have often said to me, well, you know, MEPs didn't have any power. They could never make any laws or propose any laws. I just want to give you one example that completely confounds that. And Glenys,
and then I think we need to move on. But
okay, so Glenys Wilmot, who was our EPLP leader until shortly after the Brexit referendum, had been a GMB representative working in health, and she both proposed and wrote a law on the safety of medical devices, and she did it because of the scandal of breast implants. And that, if anybody ever says to you MEPs couldn't propose or make laws, you need to remind people, you need to use that example, because everybody remembers that, the terrible stories of the women who suffered because there wasn't enough health and safety around those silicone implants. Okay, I'll finish speaking now.
Thank you so much, Julie. That's, I mean, so fascinating that a run through 6 years of experience can cover such a range of topics. It just shows you the extent to which we need that kind of political involvement at every level to protect the rights of people such as your local constituents in the Northwest. And what a loss it is that we don't have that voice at that level. I suppose looking to see how space in that vacuum might be used for nefarious means or activities is where Grahame would come in to tell us how we see the employment law developing over the coming years and workers' rights and where this government might be taking them. So over to you, Grahame. Thank you.
Thanks, Ahmad, and thank you everybody for joining us on a very momentous day. It's been quite an emotional day, not least for my mother-in-law, who is now only the second most powerful South Indian woman in the world. I was reminded when being asked to talk about this topic of a meme that has been doing the rounds for at least the last 4 years. And it's particularly apposite when you talk about Brexit and when you talk about the Tories being let loose in relation to our employment rights. And the meme went like this: I never thought leopards would eat my face, sobs woman who voted for the leopards eating people's faces party. Now, the political reality in the UK, I'm afraid, is that we are indeed governed for at least the next 3 or 4 years by the leopards eating people's faces party. And no one should be under any illusions that these particular leopards are salivating at the prospect of putting workers' rights on the bonfire. We read only this morning, or perhaps it was yesterday, that the Tories have, lo and behold, decided that they are going to do, in inverted commas, a review of employment rights. If I had a mortgage, would bet it on those workers' rights not being improved or extended, but being changed detrimentally. The Prime Minister, back when he was Foreign Secretary, was quizzed on employment rights. And he said that the Working Time Directive, many directives and regulations emanating from Brussels have, either through gold plating in this country or simply because of poor drafting or whatever, been too expensive. they are not tailored to the needs of this economy. Well, I'm not an economist, but I am an employment lawyer, and I have certain views about that sort of attitude. EU-derived employment rights are by no means comprehensive, but they are distinctly important, especially in a modern economy. And I'm thinking in particular of the rights and the legislation that pertain to discrimination in the workplace and to working time. And our own Supreme Court is, perhaps as we speak, deliberating certain very important matters in relation to working time, and in particular for carers. And it's a point I'll come back to in just a second, because I think one of the features of employment rights in this country is that because politically we are a tremendously polarized country, we find that we need, in essence, to be led by employment regulations coming from Europe, because it's too politically toxic for a Tory-led government to actually do anything on those issues. And I'm thinking in particular about scenes we've seen over the last few days where a majority, I'm sure, of Tory MPs thought, yes, indeed, let's not get rid of £20 universal credit problem, or yes, indeed, let's pay for children to have meals during the school holidays. But don't you just know it? We can't vote for that because it's the Labour Party who wants it, and we have to show that we can't give in to what they want. Well, I think you can probably say the same for lots of employment rights for the majority of moderate Tory MPs, such as they are. You can't lead the way with employment rights because that's the sort of thing that those people on the other side of the room want. And instead, we have to be led into it by directives coming from on high. You may know I chair the employment group of the Society of Labour Lawyers per se, and we are leading on a policy report on the future of work and the future of employment rights. And one of the really important things that I think a nettle that has to be grasped is this question about carers and carers' rights. And one of the things we're looking at is whether or not having caring responsibilities ought to be enshrined in domestic legislation as a protected characteristic in the way that your sex or your race or your sexuality might be. But the bottom line, I'm afraid, is that a government with an 80-seat majority and no EU treaty obligations, if I can put it like that, can do whatever the hell it likes. So the question is, what, if any, EU treaty obligations, to use that in a broad sense, does the government have? What has it signed up to in the Brexit withdrawal deal? Well, not a great deal, if I can put it bluntly. John Morgan and I, who, John of course chairs the Junior Labour Lawyers, were advising the Shadow Cabinet just at the start of the year about the trade deal that has been entered into. And one of the main points about it is the prism through which the trade deal looks at employment rights. What it says is this: neither the UK nor EU shall weaken or reduce, and this is the important part, in a manner affecting trade or investment between the parties, its labour and social levels of protection below the level in place at the end of the transition period. So there's a few points to make about that. First of all, there's not a no regression clause. It's not no regression. It's just regression in a way that affects trade and investment, and only trade and investment between the parties. Now, to my mind, and I dare say to many people on this call, that's a rather dispiriting way of thinking about employment rights. To me, employment rights and workers' rights are not mere adjuncts of international trade policy and how profitable an economy can be. But of course, that is the sort of analysis that is merely assumed by this trade deal. In fact, I'd go so far as to say the opposite. And when you look at questions in particular in relation to working time, the economy is strengthened. The productivity of a country is improved when actually you strengthen working time protections. and you know, we like to scoff in our English way, but probably look enviously across the English Channel when we see how great working time protections are in France, and yet their productivity is so much better than ours. You would think there might be a link. Indeed, I think there is. And so it is not only dispiriting, but positively wrong to analyse increasing worker protections as necessarily meaning that is a drain on the competitiveness of the economy. But that, I'm afraid, is what's happening here. But of course, what does it mean to say that the UK shall not change its worker protections in a way that adversely affects trade and investment with the EU? Let's say tomorrow, and frankly, I'm going to touch wood while I say it, the government decided, well, we are going to abolish the right to claim unfair dismissal, except in cases of discrimination and whistleblowing or something. But I tell you what, we're going to make union membership mandatory. Let's say you completely recalibrate the way in which workers are protected like that. Who on earth is going to analyse, much less come to a distinct conclusion on whether or not in the round the ways in which the Tory government have tinkered with employment rights affects the ability of, I don't know, a Hungarian bank investing in Britain? Crazy. And as I say, dispiriting in its analysis. The second thing to say, apart from the dispiriting nature of that analysis, is this: there is an active disincentive in improving standards in this trade deal. And what the EU wanted when we kicked off these negotiations was what you call a ratchet provision, where if one side improved protections, well, the other side had to come up to snuff and you wouldn't go backwards. Well, there's precisely no point whatsoever in the EU improving its standards now, because the EU's under no obligation, the UK's under no obligation to do the same, and vice versa. And the third thing I'll say about the future of employment rights, as enshrined in this deal, is the enforcement provisions are not worth speaking about, frankly. There is no mechanism, as there are with other parts of the trade deal, to actually enforce any of this. What you have is a right on the part of either side to take countermeasures if they fancy it, to then enter into discussions with the other side if the other side thinks, no, those countermeasures aren't very fair. And then for a panel of experts, not judges, not third parties of any description, to determine whether or not they think those countermeasures are proportionate. But you know what? If they're not proportionate, well, we're not going to do anything about it because they're not directly enforceable. These rulings, these opinions aren't directly enforceable anyway. Now, I'm not an international trade lawyer by any stretch of the imagination, but having read around this, and the Institute for Employment Rights has done a very good series of articles on its website about this very question, and this is what John and I were talking to the Shadow Cabinet about. Experience serves to show that actually we have seen how laborious and difficult trade negotiations have been on Brexit. Is the European Union going to put up with a little bit of friction over employment rights? Yeah, probably. Are we going to put up with it when, Poland decides that it's going to increase its minimum redundancy payment or something? Yes, of course we are. Are any of these rights directly enforceable by either workers or trade unions? No, of course they're not. So to my mind, and I've read through this and I've read the learning such as it is, frankly, the extent to which these rights are protected at all is little more than a thing writ in water. So that's all I wanted to say about those points. I'm very sorry on what is a happy day, and I'm literally watching CNN out of the corner of my eye over there, to have told this story of doom and gloom, but I'm afraid, having voted for the Leopards Eating Faces party, we might find ourselves having our faces eaten by leopards.
Well, I hesitate to say thank you, Graham, but thank you for that incredibly sunny view of the next few years of, um, of employment law and workers' rights, and I'm sure story after story of that being eroded based on your comments there. So I expect your eyes will be up and right, so that you can keep focused on something a bit more joyful for the next bit of time, because I fear that it's going to get a little bit more depressing, with Bella, who's going to talk to us now about some of the direct impacts. And I suppose I should say, from an immigration perspective, and whilst I'm not as familiar with Bella on the issue she's going to raise, the impact is really much more immediate on people. These are things that people are going through right now, and none more so than those that Bella will now discuss. So Bella, over to you.
Thanks, Ahmad. Yeah, I certainly don't have a very sunny picture to paint either, unfortunately. So as Ahmad mentioned earlier when he introduced me, my name's Bella, and I'm a lawyer at Safe Passage, which is a charity that works to reunite unaccompanied asylum-seeking children in Europe with their family members in the UK. And I'm also joint CEO and co-founder of a charity called Here for Good, which primarily assists vulnerable European nationals and their family members to secure their status in the UK post-Brexit. So I'm going to talk about the impact that Brexit has had on migrants' rights, drawing from the work that I do in this space. And a lot has changed. And so to try and focus my discussion, I'm going to touch on the effects of Brexit on three groups of people. So firstly, unaccompanied asylum-seeking children and separated families in Europe with family members in the UK. Secondly, asylum seekers that reach the UK through irregular routes. And finally, European citizens and their family members who were resident in the UK prior to the 31st of December 2020 and now have to apply for status to stay here. So beginning with unaccompanied asylum-seeking children first, put simply, Brexit has made it a lot harder for unaccompanied asylum-seeking children and separated families in Europe to reunite with their family members in the UK. This is because the UK is no longer party to something called the Dublin III regulation and its established route for family reunion. So the Dublin III regulation is essentially an European interstate mechanism which provides a hierarchy of criteria for determining which member state should be responsible for processing a person's asylum claim. At the top of that hierarchy is family reunion. So prior to the end of 2020, in practice, what the Dublin III regulation meant was that if an unaccompanied child in a refugee camp in Greece or France had, for example, a sibling, parent, grandparent, uncle, or aunt in the UK, they could be transferred to the UK to have their asylum claim considered here. Over the past years, hundreds of unaccompanied asylum-seeking children and separated families, many of whom were living in really inhumane conditions in refugee camps, have been reunited with their UK-based family members using this route. However, as a result of Brexit from 2021, this route is no longer available. At present, there is no UK-EU agreement on family reunification. Last year, the government voted down a cross-party amendment that would have protected the family reunion rules under the Dublin regulation. And what this means is that the only route for unaccompanied asylum-seeking children and separated families in Europe to reunite with their UK-based family members is for them to make an application under the UK's current domestic immigration rules. So the problem is that these rules are much more restrictive than the family reunion rules under the Dublin regulation and also have a much higher evidential burden. So at Safe Passage, we estimate that as many as 95% of our cases that were eligible for family reunion to the UK under the Dublin regulations would not be eligible or able to make an application under the UK immigration rules. What this essentially means is that there will be hundreds of unaccompanied asylum-seeking children and separated families in Europe who have now lost their right to be reunited with their family member in the UK. This legal route to the UK is now closed for them. At Safe Passage, we'll be assisting a number of these children to make entry clearance applications under the UK immigration rules, but this will be done with the expectation that the applications are very likely to be refused by the Home Office at the first instance and drag out into a lengthy appeals process. Now, the other side of this Dublin regulation, which we are no longer part of, is that the UK was previously able to return adult asylum seekers to Europe if they did not have family here and they had passed through a different European member state before arriving in the UK. The UK can no longer do this, and in acknowledgement of this, many of you may be aware of the frantic effort the government tried to make to remove as many asylum seekers as possible to Europe before the end of last year. So to try and mitigate the impact of no longer being able to return asylum seekers to Europe in this manner, the government have put in place new and very concerning inadmissibility rules. What these inadmissibility rules say, in short, is that if an asylum seeker arrives in the UK irregularly, they can have their asylum claim declared inadmissible if they travelled through or have a connection with a country deemed as safe. These rules then allow the government to remove asylum seekers to any third country in the world deemed safe, not only to countries they have passed through on their journey to the UK, but to any country willing to accept them. Currently, as far as we are aware, the government has not successfully made any agreements with third countries to remove asylum seekers to them. According to the Home Office's guidance on these new rules, in most cases, officials will have 6 months to make an inadmissibility decision. And if no country is willing to accept an asylum seeker within this period, the asylum claim will then be considered in the UK. Organisations fear that these new rules are therefore likely to only cause further delays and chaos in an already broken asylum system. They will leave asylum seekers in a state of limbo while officials try to find a third country that will take them. There is also increasing concern about the accommodation and support that these asylum seekers will receive while they wait for the UK to decide what to do with them. The new rules are also legally questionable, to say the least, and there are concerns over their compatibility with the 1951 Refugee Convention. Under the Refugee Convention, there is no obligation for refugees to seek asylum in the first country they reach, and this has been upheld by UK case law. A refugee is a person who, owing to a well-founded fear of being persecuted for reasons of race, religion, nationality, member of a particular social group or political opinion, is outside their country of origin and is unable to avail themselves to the protection of that country. Whether the person has travelled through several countries before claiming asylum simply has no bearing on whether they have a well-founded fear of persecution in their country of origin. So the government states that the purpose of these inadmissibility rules is to stop people taking dangerous and illegal journeys across the Channel and use safe and legal routes instead. However, studies show that destination preferences of asylum seekers are rarely shaped by deterrent migration policies of receiving countries. Furthermore, there's a complete absence of safe routes for asylum seekers to take. As noted, the safe route of family reunification under the Dublin regulation has ended, and refugee resettlement programmes were halted last year due to the pandemic and are yet to restart. So I guess, in short, the second effect of Brexit is that the UK is completely turning its back on asylum seekers and refugees. In general, we have an extremely limited number of refugee claims made in the UK compared to other European countries such as France and Germany. And the government is now seeking to limit that number even further by these extremely badly thought out and unfair new inadmissibility rules. So finally, I would like to talk about the effect of Brexit on European citizens and their family members who were living in the UK prior to the 31st of December 2020. Brexit has brought with it the end of free movement for goods, for services, and of course for people. This means that European citizens and their family members no longer automatically have the right to come and live, work, and study in the UK. For those living in the UK prior to the end of the Brexit transition period, the government set up something called the EU Settlement Scheme. Now, this scheme is designed to enable these European citizens and their family members to secure their status in the UK. Millions have now applied under this scheme, and the process is relatively simple for the vast majority. However, for the most vulnerable in society, it is extremely challenging. It requires people that have evidence of their residence and valid ID, which, for example, for those experiencing homelessness or victims of domestic violence, can be extremely difficult. It also requires digital literacy, given the scheme is app-based and European citizens are only granted a digital status under it rather than a physical immigration document. The government seems to be adopting a mindset whereby they will be satisfied if the majority of European citizens and their family members are able to apply under the scheme. Our concern at Here for Good, however, is that thousands of people will not be able to apply before the scheme's June 2021 deadline, and after this date will have no lawful status in the UK and will feel the full force of the UK's hostile environment. They will be unable to work, unable to rent, unable to access benefits, and liable to removal from the UK. At Here for Good, we primarily assist the homeless, those in financial hardship, victims of domestic violence and trafficking, children in care, and the elderly to secure their status under the scheme. And we fear that a huge number of society's most vulnerable will not be able to make an application in time. The parallels between the inevitable implications of the EU settlement scheme and its deadline and the recent Windrush scandal are plain for all to see. Despite this, the government is yet to publish a detailed policy about who will be able to apply after the 30th of June 2021 deadline and the leniency they may or may not afford to such applicants. So to sum up, the focus of today's conversation, I understand, is the impact of Brexit on people. I think the overriding message here is that for the most vulnerable, Brexit has only really made things worse. It has made it harder for unaccompanied children stuck in refugee camps in Europe to be reunited with their family members in the UK. It has sped up the government's attempts to demonise asylum seekers, and it looks set to result in thousands of European citizens being stripped of their rights overnight. So yes, unfortunately, not a particularly sunny picture from me either. But I'll now hand you back to Ahmad.
Thank you. Thank you, Bella. Thank you. That's I've done a bit of work with Bella on Here for Good, and hearing the overview of what she sees of all the applications compared to just seeing it happen in one case or two does make it far more depressing a view than in each particular situation, because it is happening to so many people, those thousands of people you refer to who will be struggling as we get nearer to the 30th of June 2021. Just to I'll make it, well, first of all, I should say, hello, my name's Ahmad Namazie, and I'm Vice Chair of the Junior Labour Lawyers, because I failed to introduce myself earlier. And I'm an immigration solicitor. And I'm going to just make a couple of comments about the new points-based system that the government have introduced to evolve the previous points-based system, because we have had a points-based system since 2008. Due to Brexit, to include EU nationals coming to the UK for the purposes of work. So the system that Bella discussed, the scheme, the EU settlement scheme, is in many ways that transition for EU nationals to the new rules, and covers those who would be in the UK for personal reasons, family reasons, and just living, because free movement allowed all of the above. From the 1st of December, a new points-based system was available for EU citizens who were coming to the UK for the purpose of work. And from the 1st of January, any newly arriving European national in the UK coming to work is required to have a status under this new points-based system, with the primary status for work being the skilled worker visa, which is an evolution of the previous Tier 2 general visa permission. As you can imagine, there's a certain amount of confusion when an entire system shifts to a new system, and there are a number, as I'm sure those who have dealt with Home Office or generally government technology have experienced, there's a number of glitches, making it very difficult for individuals to enforce their rights or access their rights to applications. But away from those bits and pieces, what seems to be the case for a lot of people, who, particularly those from the EU, is the lack of information that they've had access to in order to make these applications. I took a call recently from an individual studying a PhD in Lithuania who was expecting to come to the UK having reviewed the Australian points-based system, and on the basis of the Australian points-based system, expecting that she would have status in the UK because she met those rules. So deep has the rhetoric about Australian points-based systems been felt. So the information shared about the new system is poor, and that makes that access to a right to status very difficult for many. But more specifically, so the immediate impact for those coming to the UK to work from the EU is significant, and it's an impact not only on individuals, albeit in a very different way to those who are seeking asylum or coming for family reunion. And it is also a big impact on business, those who employ people from outside the UK. Somebody coming to the UK under free movement to work had no fees to pay, arrived in the UK, showed their passport to their employer, and worked as they would do if they were a settled person or a British national. Now, for an EU national to do the same, they will need to submit an application form to the Home Office, verify their identity using an app, which on all my applications has still not worked yet. So that's made the first few weeks of this year very frustrating. They will have to pay thousands of pounds between themselves and an employer through the immigration skills charge, which can be as much as £1,000 per year applied for. They will have to pay the NHS surcharge, despite the fact they will be paying national insurance, and their national insurance contributions will of course go to the NHS as they would do for any British person paying national insurance. And quite significantly, actually, there is an English language requirement for these applications, and so people who formerly would not need to have met a certain standard of English as set by the Home Office are now required to meet that standard of English language as set by the Home Office and provide the very prescriptive required documentation, which again is a double check on who, and restriction on who can come to the UK. You have the requirement for an individual to have employment, and a requirement for them to meet this English language minimum threshold. The ability to move to the UK for an EU worker is restricted. And conversely, and this might be the only positive comment that any of us have made, I think, this evening, there is the new points-based system, whilst more difficult for EU nationals, has made access to the UK labour market far easier in many ways for people from outside the European Union. The salary requirements for the majority of occupations are lower than they would have been under the equivalent points-based system occupation codes last year and previously. The type of occupation that individuals can apply to come to the UK under has broadened out significantly and includes a much larger number of occupations that meet the needs of far more sectors of the economy, rather than essentially software technicians and finance and similar. And there are really positive changes for people coming to the UK to work in for the NHS, to work in health and care, with reductions in fees and similar benefits for those processes. So there is that small glimmer of positive news for non-EEA nationals applying to work in the UK, albeit albeit not matched for those coming from the EU, for whom the process is far more onerous. And it will restrict and it will limit the desirability of people to come to the UK to work from EU countries, where that movement was frictionless previously. The most surprising thing that I believe from the shift from the old system to the new system is actually not really to do with people. So it's possible it shouldn't be mentioned this week, and is something that might need to be mentioned next week when the JLL looks at its second discussion on trade and business and the impact of Brexit on those. It's the sponsor license obligations for businesses in the UK who wish to employ European nationals. Previously, as I say, they would just check a European passport and that was sufficient for an individual to work. Now, alongside the onerous fees, a large number of organisations are going to have to go through a sponsor license application, which is a costly and an intrusive process into their business. Manage a sponsor license and the obligations, record-keeping obligations, reporting obligations to the Home Office that come with that, with criminal and civil liability to sometimes quite minor infractions, but usually significant infractions. And in many cases, this will be to employ an individual who 3 weeks ago could come to the UK for free and work for free. So this is not just a huge impact on individuals. It's a huge impact on, it's a huge burden on business. And in my experience of business, that will filter down to people. There will be there is strong evidence that the higher the higher rates of migration lead to higher employment in the resident labour market, and that looks like it will be hit by this, because businesses won't be able to operate in that same way, and because the fees, particularly the immigration skills charge, are just so high. So it's yeah. So I mean that's essentially all there is to say about that shift. There are obviously a number of different ways in which immigration is going to continue to evolve, but that shift away from the previous points-based system has had a significant impact, and will be felt, I'm sure, by many businesses and certainly by individuals coming to the UK, who I think are going to plan to move elsewhere for work. So before we that was a very quick comment on that part of immigration. I didn't want to go into too much detail, and I am aware that we haven't looked at the rights and options for people going the other way to Europe from the UK and rights there, but of course we can't talk about every impact that Brexit will have, because we would never stop talking. We'll move on to some questions. I think we've got a couple in the chat, and I'll open up to people who want to ask in a moment. And I'm hoping Joe can help me in doing that if there's any kind of technical functioning that needs to be done. But before we do that, I would like to take the opportunity to ask, first of all, to thank our speakers, and to ask Julie a very quick question, if I may. Thank you. Back on. So, and it just in respect of the protections you're talking about, the incredibly diverse work that you were engaged in and the MEPs were engaged in, and not having UK involvement at that level, where do you see, and considering we have a Conservative government today, where do you see the avenues for that kind of work now? And I suppose from a personal perspective, how do you keep providing that protection, that support?
Well, you'd be interested to know that I'm currently working for City of Sanctuary, the Welcome Refugee Network. that operates across the UK. So, and in fact, I didn't talk about it, but I did loads of work with unaccompanied minors. I actually gave evidence to the House of Lords on unaccompanied minors. And I've been very heartened by listening to my colleagues at City of Sanctuary. So City of Sanctuary is a charity, and it can't be seen to be critical of the government, who I suppose in some ways are, because of those very there's very worrying charity laws that came in, which kind of frightened everybody, so much so that lots of organisations in the lead up to the referendum didn't campaign. They were so worried to be perceived to be political. Anyway, what I do think is that there's an incredible number of people with amazing experiences and drive and commitment to those kind of ethical values and inclusion, who are finding ways to work in civil society, if you like, in the organizations and the networks that that have existed previously to do this work, but are even more needed now. I'm also I'm a patron of an organisation called Europea, which is a Manchester-based charity that was set up over 10 years ago to support EU 27 citizens who found, who had come to live within Greater Manchester and Lancashire. And so it's one of the civil society networks and organisations that I was working really, really closely with when I was an MEP. And I am a patron, and I'm doing more and more work with them now, post-Brexit. And in fact, they just appeared on Granada Kush, who is the director of that organisation, got in touch with me yesterday because they had been asked to make comments about, about the difficulties for your EU citizens to get, exactly everything that Bella was saying about settled status and pre-settled status. So I think that these organisations, which kind of cut their teeth, a while ago, are actually upping their game right now. And if there's one, there are some good things, there is not many good things to come out of COVID, but one of the good things to come out of it has been the time that we've all spent connecting with each other, and the way that we've increased our education and learning through that. I have attended probably hundreds of Zoom conferences and webinars and all sorts of things, not always as a speaker, often as a person who wanted to learn, who wanted to continue to make those relationships and those networks. And so, coming into brushing shoulders virtually with other people like ourselves is actually the thing that's keeping me focused, I think, keeping me sane. And then I'm really involved in the campaign with Another Europe is Possible. So and we have a very strong pro-migrant, campaigning strategy, if you like, ethos within Another Europe is Possible. We try very hard to present a critical pro-European sort of left view. It's Another Europe is Possible is not a Labour organisation, because it's got people from the Green Party involved, and people from Left Unity, and people from Syriza, and people who aren't in any political party. But it was, broadly on the left, pro-European but critical. And tonight, they're meeting, I'm on the National Committee, and in fact they're meeting tonight, and they're talking about exactly the same thing that we are talking here. And so we put together an alternative mandate for Brexit. I feel what we're doing is keeping those spaces open, because the Labour Party at the minute does not feel brave enough. I think the Labour Party feels so bruised by the past few years, by the results of the general election in December last year, and that it seems that many people in the PLP haven't got enough kind of you know, are too timid. I mean, personally, I would not have voted for the deal. I mean, I think it's going to come back and bite us big time, and I already see that happening. There was a debate yesterday about the musicians, you know, about what's happened to the musicians in music and arts industry. And one of the things that the minister said, Caroline Dinenage, I think she's called, one of the things that she said was, oh, but Labour voted for it. Labour knew what they were voting for. You know, I mean, unfortunately, Keir Starmer made the decision to vote for the deal before he'd even seen the text. And that will come back and bite us. But I think it's our job, you know, I mean, regardless of what you think about the party, every morning I wake up and I think I'm going to leave it. And then I sort of, you know, decide that actually I've got to stay here and fight. And I have been consistent. It's one of the things I said in my opening speech. I was consistent from the day I stood as a candidate, and I'm still being consistent. And that is, you know, our place is to be there. And we've got to make, you know, we've got to maintain and strengthen the relationships, but we've got to keep that space. We've got to keep that space open and keep saying, you know, we're pro migrants, we're pro refugees, you know, and that is part of what we should be as an internationalist party.
Yes, yeah, thank you, Julie. That's really, I mean, yeah, lots of different ways to keep fighting for those rights, and the fact that straight away you had that answer, those organisations really shows that it's a very real continued fight that you're engaged in. So thank you so much for that answer. John Morgan has asked, I don't know why his surname's John, has asked a couple of questions. So Graham, I don't know if you've seen it in the chat, you could take a view on John's first comment and your thoughts about, I'm going to read it out because I'm not familiar with it, non-regression mechanism that you covered in your talk.
Yeah, he talks about the expert panel dispute resolution mechanism as opposed to arbitration. Couple of things to say about that. So all of this is dealt with in, I think it's Title 11 of the deal, right? And it makes clear in, I think it's Article 6 or 7, I think, that this is separate from the ordinary dispute resolution mechanism from the rest of the deal. So if we're going to argue about fish, we've got something, but employment rights for some reason are encapsulated within this sort of second-rate dispute resolution mechanism. And what that provides for is, as I've already set out, a sort of consultative talk between the parties about what's happened, and failing that, this panel of experts, non-binding recommendations. Now, if a party then refuses to accept and comply with non-binding recommendations, as I dare say they will, then that allows the other side to adopt a unilateral measure. Now, they are by definition, at least according to this title, the title that deals with it, temporary. But the same mechanism allows the guilty party, in response to a countermeasure, to take its own retribution. And so what you end up with is a sort of arms race. In those circumstances, if you think the other side has taken measures that are disproportionate, and if they think your retribution is disproportionate, then you are allowed, all that way along the line, to go to arbitration. Now, and that, I think, John, is what you're talking about, the arbitration mechanism being separate. So it's the end of the line after all of this non-binding stuff. So first of all, first thing to say is you only get there once you're in an arms race. It is a lengthy process. And I think I read somewhere that there's an equivalent mechanism in a deal that the EU's got with either Japan or Korea. And they got into a dispute 2 years ago and they've still barely begun dealing with it. So it's a very lengthy process. And the point I made earlier, it's not as if a worker or a trade union could actually start this. So it depends on the governments actually going through this process. And as I said, experience serves to show they won't bother. Frankly, I would put some money on there'll just be a political fudge. You know, you can imagine new German Chancellor, Tory Prime Minister, Macron, they sit around a table, they decide, you know what, let's leave this to one side, we'll come up with some fudge, and you know what, it'll be workers' rights that end up being screwed over. So yeah, there's an arbitration mechanism, but it's very much a second-rate path to remedy, I think.
Thank you, Graham. And John has asked another question of Bella. I don't know, Bella, if you've seen that and you're able to comment.
Yeah, so John has asked, for those of you, I'm not sure if attendees can see, he's asked that whether the UK's withdrawal from Dublin could be remedied by political means, for example, cooperation between France and the UK. In short, I think no, not really. And the main reason for this is that the European Commission will not let individual member states bilaterally come to legally binding agreements on issues relating to asylum, return and legal migration. And so it's essentially that we won't see a situation where the UK can come to a single agreement with France that kind of enshrines the rights that were in the Dublin regulation for unaccompanied asylum-seeking children to reunite with their family members in the UK due to the European kind of legal framework. And so I think it's unlikely. I know that there are discussions happening between the French and UK border forces, but I think it's unlikely that this results in kind of the rights that these children had to family reunion before. The only real way to is for the UK to make a bilateral agreement with the whole of the EU, or for the UK to implement different rules into their own immigration law, which the government voted down last year.
And Bella, can I ask a quick follow-up question? Well, not about that issue, but about some ongoing campaigns for asylum seekers to have the right to work whilst they're waiting for their decision, or their decisions pending. Because, as you referred to earlier, it can be such a long wait for individuals to receive a status decision from the Home Office as to whether or not they can remain in the UK or not. Do you think that this very sharp shift in the last few months by the government, what seems like a very sharp shift, although perhaps we shouldn't be surprised, by the government in the last few months in relation to asylum seekers, makes the, I suppose, political context around asylum seekers an impossible one for campaign groups to really make any headway with legal changes in the law, or extra permissions for groups such as asylum seekers, such as permission to work?
Yeah, I mean,
or do you think things like that could still get through if people fought for? I
mean, I think that campaigners should continue to fight for them, but I think it's very unlikely that the government is going to grant. I mean, the government seems to be taking rights away from asylum seekers rather than increasing them. And I think it's extremely unlikely that they're going to grant more rights for them, particularly those that are now waiting for the government to decide whether their claim will be considered in the UK or not. I can't see them ever granting those asylum seekers the right to work when they don't grant others at the moment. But having said that, I don't think that should stop people from campaigning on the issue, because it's a huge issue, and there are going to be even longer delays with this new system, where people can be waiting up to 1.5 years before they get status, at which point many people will fall destitute.
Thank you. Just a nice return to again. Graham, I think there's a question there which has lots of references to acts, so I'm not going to read out the question, but if you've taken a look at it.
Sure. So Ernest has asked me a very difficult question about why on earth would the Tories enact legislation, and he speaks in particular of the Employment Rights Act, which really is the sort of fundamental source of most statutory employment law, albeit not discrimination law and stuff like that. Tulraka, which is about trade unions, and then the flexible working regs in 2014. This is more of a history question than it is a legal question. And I'm going to some extent duck the question by saying, do you know what, that's a really good point and I don't know. Now, what I would say is plenty of things to criticise the Employment Rights, criticise on the Employment Rights Act, and you might note that it's it is an all-encompassing recodification of employment law rather than necessarily a improvement in workers' rights. But I confess, if you asked me what was the state of the law in 1995, I probably wouldn't be able to tell you. Tulraka, I would say, is by no means a pro-union piece of legislation, and that is very much the legislation that restricts collective bargaining and restricts the right to strike. Not necessarily pro-union, I wouldn't say. And the flexible working regs, well, yes, fair, I suppose fair point, and a lot of flexible working stuff came in around 2014, but of course, the ball was set in motion very much during the last Labour government. When you think about things like the Equality Act and you think about the sort of family-friendly leave regulations and all that sort of stuff, a lot of stuff in the second term of the last Labour government. But it's an interesting rhetorical question. Why would the Tories do good things, arguably, on those points? I'm afraid I wasn't really paying attention at the time, so I can't really say.
Thank you, Grahame. We've got a question from Yara Abbas in the question section. Thank you, Yara, for putting it in the Q&A. And it relates to youth mobility. Julie, I see you've commented that you'd like to take the question first, so I'll pass it over to yourself.
Yeah, well, I wanted to talk a little bit about the loss of Erasmus Plus anyway, because I actually helped to write the new programme and also fought for the increased budget that the EU has given to the Erasmus programme, which of course we're not part of, and shame on the government for telling lies about that and saying that, I mean, Boris Johnson, there's film of him in the House of Commons actually saying, oh, there's no threat to it, we're going to stay in it for sure. What lots of people don't realise about the Erasmus Plus programme is that it's much more than just bright students going off to spend time learning languages in each other's universities around Europe. It's the plus bit at the end of it that is really interesting and that Labour needs to learn about. And the plus bit is all the other programmes that had run previously all became subsumed under the Erasmus programme, and that's why it's a plus. So Erasmus was just the bit about students, but the Youth in Action programme, the Grundvig programme, the Leonardo programme, all these other programmes in 2014 came under the Erasmus programme, and lots of them are about broader, wider inclusion. So for example, I explained in my opening speech about working, with young people in these European exchange programs. That was Youth in Action, and that is part of the Erasmus Plus program. I know groups of young people with autism, for example, from Stockport, who participated in Erasmus Plus programs. And as a result of that, became, so and I met them in Brussels, didn't meet them in Stockport. So they'd come on a sort of summer school thing to meet other autistic young people and workers, youth workers. And as a result of doing that program, when they went back to their school in Stockport, they set up little enterprises, they did work experience, they set up little businesses, they even got some apprenticeships and jobs. And I'm talking about kids with autism here. And it was an EU program that gave them that confidence, that ability. I also know groups of people with learning disabilities who did Erasmus Plus, and I know that when the current programs that they're involved in end, they will not be able to do them anymore. And the government scheme that has been announced to replace Erasmus doesn't talk about any of that wider inclusion and engagement. The Turing scheme really is a very it's a very limited form of the Erasmus bit, which is the student bit. And they're talking about going to you know, well, you'll be able to go off and do a program in America or Canada or whatever else. But all that costs lots and lots of money. And it's much more complicated for the universities to be making individual agreements and arrangements with UK universities than it was through, if you like, that overarching scheme. And it's also not well known in the Labour Party and by Labour front bench, right, that the Erasmus scheme was already working in many of those countries, right? So this new iteration of the programme, you know, which has just literally started at the beginning of January, has been, you know, I think it involves Australia, it involves all these other countries. So we've actually, you know, what have we done? We've really, really shot ourselves in the foot by coming out of a brilliant programme that is over 50, you know, that has got an incredible kind of track record. Is it 30 years it's been going or longer? It's amazing. And, you know, could have given people that, that ability. So I think that, you know, I mean, if touring is what it's going to be, then we have to take steps to make touring plus, okay? We have to say, we don't just want the touring bit, we want all the other bits that were with the Erasmus programme. I mean, the Grundtvig programme was about educators learning from other educators, for example, you know, by sharing practice, going on courses together. So there's a lot of work to do, but we ought to be aiming to replicate the Erasmus Plus programme as much as possible, which probably means rejoining it, actually.
Yeah, and just to, sorry to jump in, Julie, I just wanted to put a quick comment in how some existing youth mobility visa provisions could be extended in light of Brexit in a way that they don't seem to have been. And then very conscious that we need to get to a couple of last questions before wrapping up by 8. And those provisions are to look at the Tier 5 youth mobility visa option now and extend that to a wider set of countries, extend it to European countries, and perhaps amend the requirements for aspects of the subsection, the sub tiers, I suppose, of the scheme. So have a youth mobility that focuses on, you could have a youth mobility scheme that's extended, or you could even, and this is what I think Labour should do, is have a youth mobility scheme under something like Tier 5 that extends to skill-specific or industry-specific areas that have specific agendas. And I'm thinking specifically with people who wish to come to the UK to study sustainability and related in related fields, whether it's engineering or similar, because we've got fantastic universities dealing with those areas, and there are countries that we could have reciprocal arrangements with, where we could engage in knowledge sharing to really push that agenda forward a lot quicker than with quite a simple and straightforward shift in tinker with one small visa policy. And then I think, as you'll be aware, the new graduate scheme that's coming out, extending that to include more a wider net as well. That's another option. Perhaps European graduates from certain European countries, or European graduates, or graduates from any university around the world, although that would be administratively unworkable, I imagine. There's one more question that I can see for Grahame, and Grahame, if you could answer it really, really quickly, and then we could wrap up about, I think that's the last question I can see about EU laws. Another question from John there.
Yeah, John asks, what is the low-hanging fruit? Well, he's hit the big ones, I think: working time regs, agency worker regs. I think things to do with flexible working and family working, the Tories will analyse as being too business unfriendly. The other angle that they may well go for, depending on how fundamental their so-called review is who actually gets any of these rights anyway. And that's always a perennial topic of discussion among employment lawyers. It's great being an employee, but if you're on a 0 hours contract, or you're a worker, or you're in some other form of relationship with your employer, they owe you less in the way of rights. And I wouldn't put it past the Tories to restrict the field of application for these rights, all the while saying, oh, no, don't worry, we've done nothing to those rights. And in fact, we've improved them. So that's, I think, where the low-hanging fruit will be.
Thank you, Grahame. I think because we don't have any questions pending, unless somebody can see one that I haven't, I will wrap it up there. First of all, I'd like to say thank you very much to Julie, Bella and Grahame for your fantastic contributions. And also thank you, each of you, to taking the questions as an opportunity to talk as much about possible solutions and benefits of the things we've lost, rather than continuing with what was the theme of all of our discussions. Essentially, things aren't looking as sunny as they could. I will quickly mention that there was, because some of the comments weren't visible to everybody, there were comments in the panel, and it's good to see that there are different points of view on certain issues, but this is not the forum to discuss that openly, so I haven't mentioned it and raised it in the discussion. I hope everybody's okay with that. So thank you very much to everybody that's spoken today. Thank you so much for the questions. We have the next of our talks in relation to the impact of Brexit next week, Wednesday at the same time, and everybody attending who received the invite for this event will have received that invite, but a reminder will be sent out, and that really promises to be an interesting discussion looking through the free trade agreement and the positives and the negatives, some of which we've considered today in a bit more detail. So I do hope you'll join the JLL team next week for that. Thank you once again to all the speakers, and have a good evening.
Thanks, Ahmad. Thanks for organising.
Thanks, Ahmad. Bye-bye.
Thank you all.